All right, yeah. I don't know what you're doing with your piercing in your tongue, but we don't need to see that. Want to see it.
Oh, my bad. I'm at work. My bad.
All right, we don't do my bads here. We just don't do it. All right, so Miss, you need to be out of that bed and you're not dressed appropriately for Zoom. All right, so you're gonna have to speak up. Nobody can hear you.
I think it's just what I'm on. But yes, yes, you can hear me.
Yes, slapping somebody who has dementias and Alzheimer's. This is just somebody that somebody just hired off the street and said, hey, you have a high school diploma. You want to receive minimum wage to take care of people that nobody else maybe wants to take care of. And this is where we end up.
This case takes a sharp turn the moment Brat steps into the courtroom. She's being tried for striking an elderly woman who suffers from dementia and Alzheimer's. And from the outset, the situation spirals quickly. When she first appears before Judge Wood, she strolls in acting casual, even playing with her tongue piercing as if the proceeding were some sort of performance. That instantly sets the judge off, and tensions rise. Her next appearance, Brat shows even less regard for the process, arriving in clothes that look like she just rolled out of bed, as if court were an afterthought. This isn't a traffic citation or a minor misdemeanor. She's staring down a charge that carries the possibility of up to 20 years in prison. Yet her behavior suggests she views the whole ordeal like waiting in a coffee shop line. You can almost see the judge's restraint evaporate as Brat continues with a smug and dismissive attitude. It raises the bigger question. When someone openly disrespects the courtroom and the gravity of their charges, should that factor into whether they deserve prison time, probation, or something else entirely? Let's break down what happens next.
Miss Janisha Walton, if you want to appear on Zoom, you're going to need to have your video and you need to unmute. All right, yeah. I don't know what you're doing with your piercing in your tongue, but we don't need to see that. Want to see it.
Oh, my bad. I'm at work. My bad.
All right, we don't do my bads here. We just don't do it. So if you want to continue to appear by Zoom, you need to appear appropriately dressed, and nobody wants to see you fiddling with your tongue piercing. All right, you're going to be back on June 2nd. And June 2nd, you can appear by Zoom, but if the court finds that you are not behaving appropriately, Zoom, that will be suspended. All right, thank you. It gets to be like 60. Oh my gosh, it's too cold. All right, so Miss, you need to be out of that bed and you're not dressed appropriately for Zoom. All right, you need to put on a jacket or something, Miss.
We'll get that.
All right, Miss, you need to put on a jacket or something.
Oh, okay. You want me to call her and tell her?
Yes.
I'll text her.
All right, thank you. And I just sent her a chat.
Okay.
So if you just step to the side and I'll call you right back. And is this going to be an agreement or jury trial?
It's going to be an agreement, ma'am.
All right, so if you all will get the paperwork ready.
I have several courts to be in today. Could we do this on another day? I mean, I've got.
I mean, we're here, she's here.
Okay, and we can do it via, I believe she's in Chicago, if I'm not
Yes.
mistaken, at least Illinois.
All right,
That's
so.
fine. I can text you when the paperwork's ready.
Okay.
All right, so I'm going to put you in the waiting room and they'll get the paperwork sent to you. Ms. Ferguson will need your email and her email. All right, thank you.
Yes, Judge, we went through the paperwork earlier, so she's all set.
No, she needs to be sworn in.
Okay.
And if you go in that breakout room, the clerk will let you know if they have all the paperwork or if there's some issue.
Okay.
Please do not leave the room until someone requests you leave the room.
I know I'm trying to get back and join that room, but I don't know how to get back in.
Another room so it could pop up on your screen. And it's now room number 2. And are you Miss Walton? You need to unmute.
Yes.
All right, Miss Walton, you have a right to appear in person.
It's unmuted. Can you hear me?
Yes. Are you able to hear us?
Yes, I can.
All right, Miss Walton, you have a right to appear in person in court, but I am in receipt of a consent to plead by video conference. Did you review that document with your attorney? Did you understand it and electronically sign it?
Yes.
Did you review the application for deferred adjudication with your attorney? Did you understand it and did you electronically sign it?
Yeah.
All right, so you're gonna have to speak up. Nobody can hear you.
I think it's just what I'm on. But yes, yes. You can hear me?
Yes. Did you review the true bill of indictment? You're saying yes?
Yes, I did.
All right, did you review that with your attorney?
Yes.
Did you understand it?
Yes, I did.
Did you understand you're charged with intentionally or knowingly committing bodily injury against a child, elderly, or disabled person at a state facility?
Yes.
That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. According to the plea, punishment is to be assessed at $1,500 fine. State recommends deferred adjudication. There's to be no contact with the complainant, the anger management course, and you're prohibited from practicing as a nurse in the state of Texas. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, it is.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years, and there be 120 hours of community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? All right, anything you wish to say on behalf of your client?
My client is in Chicago. She understands, she should not have slapped this individual. She does accept responsibility for it. She would just like to move on and be able to work and complete her probation without any problems.
It's clear that, at the end of the day, Brat is hoping for probation and the chance to leave the courtroom as if nothing happened. But her conduct tells the opposite story. Flicking a tongue piercing in front of a judge, almost like a bored teenager in class, isn't just unwise, it's openly dismissive. Then comes the next appearance, where she shows up without even dressing appropriately, looking like she literally rolled straight from bed into the courtroom. That kind of presentation goes beyond simple disrespect. It signals to the court that she doesn't take the proceedings seriously and doesn't grasp the weight of the charges she's facing. With potential penalties reaching up to 2 decades in prison, a careless display like that doesn't just weaken her case, it practically erases any credibility she might have had. Judges don't only listen to legal arguments, they observe demeanor, effort, and respect. Every detail matters, from the way a person carries themselves to the effort they make in showing up prepared. If someone can't manage the basic expectation of dressing properly for court, it raises a harsh question. How could they be trusted to follow strict probation rules if given the chance?
All right, so how much training does she have in the field? Is she a licensed nurse, or is she a person that somebody hires and says, hey, we need somebody to come in as a caregiver?
She will have to answer that one.
All right, are you a licensed nurse?
No, I'm working towards getting my CNA.
All right, so this is a situation where somebody just hired you to come in and work in a facility.
I'm a caregiver.
All right, so what's your level of education to be a caregiver?
I finished high school.
All right. See, this is what I mean. Everybody's just letting everybody be a caregiver. And the problem is that being a caregiver for somebody, I think that's sort of like a calling. You have to have said, you know what, I'm going into that field, because you're dealing with people who have dementia, Alzheimer's, people who can't take care of themselves, people who need somebody to bathe them. The patient gets upset because they're not doing what they're allowed to do anymore. They can't communicate because they have dementia and Alzheimer's. Then everybody and their mothers just hiring random people, paying them minimum wage or less than. And then we end up here with somebody slapping somebody who has dementias and Alzheimer's. So I know y'all say she's prohibited from practicing as a nurse in the state of Texas. Okay, but she's not a nurse. She's not licensed to be a nurse. This is just somebody that somebody just hired off the street and said, hey, you have a high school diploma. You want to receive minimum wage to take care of people that nobody else maybe wants to take care of. And this is where we end up. And what was the name of this facility? Let me see. Chapters Living of San Antonio. All right. This is what the court is going to do. Does anybody want to speak to length of probation? The state is asking for 3 years. All right. Court is going to sentence you to 5 years deferred adjudication. There's a $1,500 fine. There is to be proof of employment within 30 days. There's to be no employment as a home health care provider, no employment with working with minors, no employment with working with people who are disabled. There's to be no practicing as a nurse in Texas or anywhere else. So I'm just going to say no practicing as a nurse. There's to be regular reporting by Zoom or in person. There's to be regular random UAs, 120 hours of community service restitution. The $1,500 fine will be probated. There's to be anger management. I'm ordering anger management because you all agreed to it, but it just appears that you were a person who should never have been working with someone in any type of facility or young children or people who have mental health issues. That's just not a field for you. Good luck to you. Don't take any more of these positions that requires you to have patience and that requires you to be with someone who has dementia, Alzheimer's, they're elderly, they need somebody to be kind and patient with them. You shouldn't work in those positions. Do you understand?
Yes.
And I do fault the company that hired you as well.
The difficult reality in cases like this is that you can never fully predict what someone might be capable of until the damage has already been done. On the outside, a person may present themselves as polite, even gentle, but behind the scenes, an entirely different side can emerge, one marked by anger and violence. That's what makes situations like this so complex, especially for employers or care facilities. Background checks only go so far, and if someone has no prior record, there's often no warning sign to catch. Judge Boyd did raise some important points during this case, but at times her focus seemed to lean heavily on flaws in the system itself rather than on the choices of the individual. And while the system certainly plays a role, accountability ultimately comes down to the person who committed the act. No policy, no employer, no loophole forced Brat to harm a vulnerable elderly woman. Those decisions were entirely her own. Then, when you pair that violence with the way she carries herself in court, showing up almost undressed, acting like the process is beneath her, it makes it hard to believe genuine change is possible. Which raises the bigger question, should the blame fall more heavily on the home care business for placing trust in the wrong person, or does the full responsibility rest on the individual who chose to lash out? Thanks for sticking with this breakdown. Now, I'd love to hear your take. Is this primarily a failure of oversight, or is it proof that personal accountability must always come first?